So those are some of the areas. Now, if the case is mediated, there are usually rules that people have to sign, like that they won't transfer assets, and that they won't remove from beneficiaries, and provide some level of safety to engage in the mediation process. Okay? So that's everything to do with preparation for a divorce. Now, basically, let's talk about the different types of divorce before we get into the more litigation areas. Okay? Mediation is a process where both parties go to one attorney, and it doesn't have to be an attorney, to resolve the problems. The attorney does not represent either party, but is there to help empower the clients and the parties involved to resolve their own issues. Okay? Team mediation is a process where there are attorneys involved, but also a mediator. So the parties bring their own attorney, they need some protection, and the mediator works with the attorneys and the clients. There's another type of divorce called collaborative, where the attorneys get special training in it, and they agree to work as a team instead of as adversaries. And there's two types of collaborative. One is informal, and one is formal. Informal means they don't sign a piece of paper saying that formal is where they sign a piece of paper, the two attorneys, that if they do not reach an agreement, they will leave the case. Then the people have to start over with new attorneys. There's a lot of controversy about that. Informal is where they agree to work on the team, but if it doesn't work out, they can stay on the case. It's not that much different than negotiations, but instead of positioning, they try to work as a team. And they may bring in those other experts I spoke about, like psychologists or financial planners, to help solve the problems. Okay? Then you get into negotiations. So how does a negotiated divorce start? Well, one lawyer might write a letter to the second lawyer and say, we'd like to work out an amicable divorce or separation. Please contact me on behalf of your client, okay? And then they might exchange those statements of net worth. And then they may exchange financial documents and try to negotiate an agreement. If that doesn't work, they may head into the litigation process. So what is the chronology of the litigation process in a divorce? In most states, it may start out with a conference. In some places, they call it a preliminary conference or a status conference. And they expect you to bring that statement of net worth to the court and the tax returns, okay, and maybe pay stubs and things like this. By the way, a pay stub is a very important document. Why? Because it has not only the income, but it may have other benefits that they're getting from their employer, okay? So basically then, they have this conference at court and they try to see what issues can be settled and what need to go forward, okay? And then they set a schedule for discovery. And that's what I want to talk to you about next, is the discovery process. The discovery process in a divorce is quite lengthy because there's a belief that there should be full financial disclosure in a matrimonial action, in a divorce action. Basically, all those documents we described above are to be exchanged. And anything else that's needed. Sometimes I need, the case with the special needs child, I needed not only his W-2 in salary, but there was deferred compensation that he gets later. There were side agreements with partners. So you might need more documents than just the basic documents. And after the first round of exchanging documents, you might need a second round, okay? So in the special needs case, now he's trying to say that the other spouse didn't take care of the child. So we may have to say, oh, he wasn't there that much, and he's a pilot, aside from a business person. So I asked for I just worked on this over the weekend. I just asked basically for all the flight log books to show when they were there and when he wasn't there. So you have to be very creative in what you ask for. And you always have to think what the other side is fighting. You know, what's their theory of the case? What are they trying to show? And how do you counteract that? Okay? In the dissipation of assets on the paramour, I had a case last year where one party had severe cancer. And it was only a 6-year marriage, but I was asking for lifetime maintenance because she could never work again. And there were assets there. And he had taken up with a new person. So basically in that case, we did end up with a stipulation that $135,000 of the assets were dissipated on the paramour, the lover. But I had to subpoena, you know, hotel bills and credit card bills, etc. So it gets quite involved, okay? On another case I had where I was helping a father obtain custody, there were forensic valuations of the parties by a psychologist. So I had to request all the psychological reports and evaluations to see what was stated about both parties and their interactions with the children, okay? Now, what's becoming a big area in this line, in family law, and I think in others, but particularly in family law, can you guess? Is issues with forensic computer and electronics. Spouses are breaking into each other's computers. There was one recent case in federal court where one spouse was having all the emails of the other spouse bounced back to his account. So one spouse brought a federal action against the wiretapping, violation of the Wiretapping Act, and civil rights issues and privacy issues. So one of the things you want to advise your clients, right, it's like who's watching who. This doesn't have to pertain to marriage. I've had many people come to me for consults in relationships without marriage where this becomes an issue, is to clean their hard drives, to change passwords, to keep track of where they're leaving their cell phones. Sometimes they put illegal devices on the cell phones, on the home phones. There's a lot of investigating and spying that could go on. And it's not so much about even adultery anymore, although some of it is. A lot of it is for financial information. I had one spouse they were separated and they had a good relationship. And it also involved a special needs child. And one spouse said, can I come into your apartment to just print something out from your computer? And they had gone back and forth between their homes. You know, that happens. There's friendly relations. Went into the computer and downloaded confidential information in the middle of a divorce and sent it to the lawyer. Say, hey, look what I found. Not acceptable. So you must tell your clients to be vigilant about protecting their privacy, maybe get new cell phones, maybe use a different computer. And there is case law that if the computer is in a public place, then that's fair game. You know, if everyone has access to that computer, then that may be fair game. So maybe they have to be more careful with confidentiality. Okay? And in matrimonial cases, we are utilizing computer forensic experts about these issues. So it's another area you have to look at. Okay? So basically, the discovery process, there's many different discovery devices. Okay? One is the statement of net worth must be exchanged. 2, there's a notice for discovery and inspection, which I've provided to you. And that's where you can request documents from the other side. 3 is interrogatories, which is written questions, which I've provided to you in detail. And you can ask written questions about all the finances, assets, debts, income, and expenses. Okay? And You can also serve subpoenas on third parties. And you can also ask for all reports. So sometimes there's a forensic accountant that's retained to evaluate businesses. You can ask for these reports, okay? So all of these documents get exchanged. You have to be very creative in your requests. Maybe you want passports to see how often someone traveled, to show they're not there that much, or to show the money that's being spent, okay? What comes after exchange of documents is the deposition, okay? The deposition is where, as you know, you question the other party under oath with a court reporter, most likely at your office or in the court. And deposition is not like a cross-examination. You're not trying to catch them. You're trying to create a dialogue. You're trying to create as much information as possible. You want open-ended questions. You want to know about the different assets, and you want to know about the history of employment. You want to know what they consider to be the contributions of each parent to raising the child. It's not a hostile situation. Now, they may feel it's hostile, but you try to create a conversation with the party you're deposing, okay? And some of it's videotaped, and some of it is just transcribed, whatever you prefer, okay? And then, in the process, you will also go back to court for status conferences. How is the discovery process going? Are you getting all the documents that you need? So I've had cases where basically we say, you know, there's a business involved. The parties owned a business together. Well, we haven't received the P&L statements, the profit and loss statements, for the last 3 years. We've asked for it several times. We have not received it, Your Honor, or the clerk, okay? We asked for the flight log information. We have not got it. We've asked for the deferred comp information. We haven't got it. So then there may be stipulations about how to get these further documents, okay? It's important to utilize mediators or the courts if you're having conflict or not getting information, all right? Some people are utilizing mediation because the courts are so busy and due to budget cuts, they can't get as involved, okay? With custody situations, while the divorce is pending, there can be enormous conflict, particularly if there's chemical dependency involved by either parent. You may get emails at all crazy hours. The boundaries seem to disappear, okay? Doesn't mean you have to answer it when they send it to you. You know, there may be emergencies, you need to respond quickly. But there's a children's bill of rights in custody cases, okay? And it is on my website, sherrydonovan.com. But basically, the parents should not be using the children as messengers. They should not be bad-mouthing each parent, okay? I had one set of parents, they both thought it was okay. Well, we don't get along, so we're going to stick notices to each other in the child's backpack. Oh, that's wonderful, you know? The child's a messenger for the parents, literally. So these type of things are a problem, okay? Not supposed to, when the child's talking to the other parent on the phone, you know, listen in or stay right on top of the child. You're not supposed to deny access unless there's good reason. I mean, I've had one case where, you know, one parent had physically abused the children and also had physically abused the mother. And so in that type of case, there may be limited access or supervised access. You know, there are situations. And it goes the other way, too. I had one case where I represented the father, and the mother was a teacher. And she had a history of felony conviction because she had sex with a student. So the judge was very careful about giving access with her own children, even though she had not had any sexual molestation with her own children. The judge ordered a forensic psychologist report before he ordered unsupervised visits. And the father was very cooperative, but it was more about the judge being careful in this case. So you don't have to watch TV or read drama novels after doing matrimonial practice. It's an interesting field. Okay? So the status conferences will let you see where you're at with discovery. Okay? Then, if that doesn't work, you will be called for a pre-trial conference. Okay? A pre-trial conference, you have a whole new set of documents to bring to the pre-trial conference. And this is if it doesn't settle beforehand, okay? And judges don't like when you're not prepared. So it's very important. What is the most important thing when you're dealing with a judge? Is to obtain a copy of the judge's rules. Many lawyers are so busy they forget to do that. You must follow those judge's rules to a T. If they don't like adjournments done on the phone, guess what? You're going to use their form to do an adjournment, okay? If they want certain documents at their conference, you are going to bring those documents, okay? So follow the judge's rules. If they don't want a notice of motion filed, they want an order to show cause filed. These are different types of motions. Then you'll do what they want, because it's very important to develop a good relationship with the court, the law clerks, the judge, because at every point you're telling your theory of the case. So the pretrial documents include, in many states, it's not all the same, and I have put them in the materials, is a witness list, an expert list. I did not include a sample exhibit list, but an exhibit list, which means that you cannot prepare for your trial at the last minute. You always have to start thinking about the documents you're going to ask in it for deposition and what type of issues for the trial, whether you have an iPad and you create separate note pages and start listing categories, or sometimes you get ideas in the middle of the night. You start writing down your ideas. You start making lists of documents you're going to need for deposition, for trial, for settlement, okay? So the pre-trial conference, you will have usually an updated statement of net worth, a witness list, an exhibit list, an expert list, and something that tells the story of your case. I've included one. It's different in different states. In New Jersey, they use an early panel form. In New York, they call it a statement of disposition. And that's where you lay out the complete story of your case. And I have seen judges put into their published decisions, well, you overstated how much maintenance you wanted in your statement of disposition. You know, it was not realistic. You have to take a lot of time to fill out these forms properly, okay? So the statement of disposition sets forward what all the marital assets are, what all the separate property is. It sets out the income, and it sets out what you're seeking in detail, down to the calculator of adding up the numbers, okay? And that's what you do for pretrial. Now, for settlement discussions, what I think you should prepare, okay, is you should have one file on your computers, or one section if you're writing things down, all the settlement offers that go back and forth. Settlement offers by you, settlement offers by the other side. Have it all like an Excel sheet, like a chart, so that you can see what the offers have been back and forth. Because that's how you're going to reach settlement. You're going to look at what you've offered, what the other side has offered, and how to reach something in the middle, okay? We're going to take a break for 10 minutes, and then after the break, I will talk to you about the substantive law on each topic a little bit in general, and then we can also take some questions, okay? Try not to get into a family altercation on the break.